Welcome back to Winning Law. I'm attorney David Nguyen with offices in Houston, Texas. And today we're going to talk about the 5 most commonly asked questions that we receive regarding wills and estate planning. Question 1. Do I need an attorney to draft my will? The simple answer is no. You can draft a will in Texas by yourself. In Texas, we can do many things by ourselves. We can build our dream house from scratch. We can self-diagnose our medical problems by going online and searching on Google. We can also install our own in-ground pool by watching an online YouTube tutorial. We could do many things in Texas by ourselves. However, the difference between doing any of these activities and drafting your own will is that if you mess up drafting your will, the only time that you'll find out is after you pass away. And by that time, it'll be too late. So if you use one of these do-it-yourself will kits like LegalZoom or Rocket Lawyer or any other kit that you receive from a department store or a retail store, if you do it incorrectly, when you go out to court, they're going to deem that the will is unenforceable and invalid. So think about that. All the power that you had to control your estate and what happens to it after you pass away is gone. All that power is given back to the government to determine who receives your property, and you have no say in that decision. Question 2. I am currently married. Do we need one will, or do we have to have 2 wills? In Texas, each party must have their own will, even if they are married. So if you are married, you cannot have one will to represent both of your interests. Question 3. Who really needs a will? In my opinion, everyone needs a will. No one knows when they're going to pass away and what they're going to have on the day that they pass away. So in my opinion, everyone needs a will. However, there are very particular social groups that definitely need a will. Other people that need a will are people with blended families. Blended families means that if you've been married before and you had children and you get married again and you have children with that new spouse, this is a blended family. You definitely want to seek having a will drawn. Other people that need a will include people that are in a committed relationship but are not yet married. Some people just don't believe in the institution of marriage. If you are one of these types of people, you definitely need a will to make sure that your partner is protected. Also, if you have a mental history or a family history of mental illness, what you want to do is draft your will now, because if you have signs of mental illness, an attorney should not be drafting any will documents for you. And if you draft will documents, they may be found unenforceable when you get out to court. Other people that need a will include people that travel often. If you travel often for personal reasons or for work, you might want to protect your family by having a will drafted just in case something happens to you while you're traveling abroad. Also, if you have minor children, you might want to think about having a will, because with the will you can designate who you want to be a guardian for your children, and also who do you want to control the estate in the event that the children are unable to receive the property because of their age. Question 4. What happens if I draft my own will and I make a mistake? So in Texas, if you make a mistake in your will, the will can become invalid and unenforceable. This means that you're going to give up all the power you had to distribute your property, and you're giving that power back to the government. Question 5. What is the difference between a basic and a living will? In Texas, a basic will is just a document that goes into effect after a person passes away or is deceased, and only goes into effect if they are deceased. This is traditionally what most people think about when they have their wills drafted. But in Texas, we have something so much better than a basic will. In Texas, you can draft a living will. A living will not only goes into effect after a person is deceased, it can also go into effect when a person is incapacitated or unable to make decisions on their own while they're still living. So a good example of this is if a person's in a coma, or if they're on an operating room table, still alive, but unable to make those decisions, or if that person later develops a mental condition that impairs their mind and memory. In this effect, you can designate someone to act on your behalf while you're still living, but not yet deceased. Thank you for watching Winning Law. I'm attorney David Nguyen, and I hope that you have found this video helpful and informative. If you do not have a will already drafted, or you have a will that's very old or outdated, I encourage you to reach out to our office. We provide free consultations regarding wills and estate planning. Thank you again for watching Winning Law, and we hope that we have made wills and estate planning easy to understand.
At David Nguyen's Law Office, we are here to help you. We bring families together through immigration. And on the other hand, we help you find solutions. All your legal needs in the hands of people who care, who are there for you. We'll take care of your loved ones at the law office of David Nguyen.